Welcome to Farm Here Daily, a Field Forward podcast. I'm your host, David Geiger. Today on Farm Here Daily, some are celebrating a legal victory for ethanol producers. Michael Buschbacher with the law firm Boyden Gray joins us to cover that. Please be sure to like and follow the podcast as well as our social media at Field Forward Pod. We would love to have you join our community, keeping folks informed about what is affecting our farmers. This is Farm Here Daily. And joining us on Farm Here Daily, we're going to go over a recent legal victory with Michael Buschbacher, partner with the law firm Boyden Gray. Michael, thank you so much for joining us on the program, and let's talk about this win for biofuels. Can you tell me first about the case before we dive into the details?
Yeah, so the case is deep in the bowels of the regulatory state. This is one of those things where complexity was used to obscure the harms that the Biden administration was trying to impose. So it's a Department of Energy regulation called the Petroleum Equivalency Factor. And basically what it does is it takes, it's designed to be the number that you plug in for CAFE fuel economy purposes for an EV. And, because they don't burn fuel, how are you going to calculate that? That's what this rule was supposed to be. And instead of providing a real world estimate, what the Biden administration did was they took the number that they estimated and then multiplied it literally by 666%. And so it meant that, something that should be getting 60, 70 miles per gallon for the calculation was getting, 400 something miles per gallon. And this was a multi-billion-dollar racket for the EV industry. And what's truly outrageous about it is it took an incentive that was originally created for E85, right? When you think about E85, it's nominally 85% ethanol, 15% gasoline. And so they had a divisor that they came up with that they used for alternative fuel vehicles running on E85, where you divide by 0.15, same as multiplying by 666%. They used that, even though it said don't use this for EVs, they used that for EVs and put it into the calculation. What the court said in this case that we brought with the state of Iowa and then our client, American Free Enterprise Chamber of Commerce, is that has no basis in law and has to stop.
So just to be clear about this, is this involving, I recall that time frame where essentially they also didn't really calculate what goes into batteries or some of the logistical aspects of having EV, and they were trying to make it comparable to biofuels in that way. Does that include this part too?
Yeah, so more broadly, the Biden administration always was trying to play up the benefits of EVs and play down the downsides, and to take anything that they could find and use it to push electrification. That's how this came about. So there's a complicated 4-factor analysis that the agency was supposed to go through. And really what they did and what the court said is they took one of those factors and just sort of read it to give them basically unlimited power to do whatever they wanted. And the court said that was like trying to find a statutory elephant hiding in a mouse hole. That's literally the phrase they use, which I love. And so what the court said is, no, that elephant does not fit in that mouse hole.
The way you described this was they gave essentially an arbitrary number to apply to the situation. How did you guys prove that was arbitrary?
Well, they admitted it. They said this was what we need to do to incentivize electrification. And that was their justification. They weren't pretending that this was a real world equivalency. They did that, and then they added on top of it this multiplier. And they didn't have any justification for that beyond, we think the world should have more electric vehicles in it. So, what we went to court and said is that's just not what the statute says. And, I argued this back in January in the 8th Circuit based in St. Louis, Missouri. And then, we got the decision late last week saying, yeah, Congress meant what it said.
We know it's a little easier to make a claim that of any kind rather than to prove that the claim was wrong. In proving the claim was wrong, did you guys encounter the actual number?
Well, the actual number is, we did have some arguments about how they calculated that. Those were more things on the edges of exactly how you do it. It's not super easy to calculate what the equivalency is. There are different numbers that could be a plausible answer to that. based on things like the efficiency of the transmission of electricity from the power generation to the the charger and into the EV. Those kind of questions. There were some problems, but they were much less big of a deal than just this multiplier that was tacked on at the end. So what's going to happen now is the agency is going to have to figure out what to do with this. And what the court said is that they can't use this multiplier again. Now, no worries about the Trump administration wanting to do that. But what this says, which is really important, is that this is what the law requires. And so it means they can't ever go back in the future. If there's a Gavin Newsom presidency in a few years, Gavin Newsom's administration can't come in and bring this back now. It's dead. So that kills I think some estimates put it like $10 billion a year cross subsidy, where people buying ordinary cars were paying to make EVs cheaper, so that so that they could push their electrification aims. So it's a big development.
This is Farm Here Daily. We'll have more in just a moment, but first let's take a look at the marketplace. There was green at the close on Monday. December corn 3 3/4 cents higher, 4.21 3/4, with March rising 3 cents at 4.39 1/2. Soybeans in November 6 3/4 more, 10.33 3/4, with January an increase of 7 1/4 at 10.52 3/4. Soybean meal in October $1.40 a ton, in the green $281.90. Soybean oil in October is a fifth of a penny higher, $50.98 a pound. December wheat 4.5 cents more, 5.23 3/4, with March 5.5 cents up, 5.41 1/4. Hard red winter wheat in December 12 cents higher, 5.17 1/4, with March up 12 cents as well, 5.37 3/4. In the livestock market close for Monday, October live cattle down 17 cents a hundredweight, $235.80. December rising 12 cents, $237.57 a hundredweight. Feeder cattle in September, $1.12 a hundredweight more, $360.95, with October an increase of $1.27 at $359.17. Lean hogs in October, 87 cents a hundredweight lower at $95.15, with December falling 17 cents at $88.15 a hundredweight. That is the Monday market close. This is Farm Here Daily. I want to dive into what this means for the next step. But before we get into that, was this really a everyone's grabbing from the same pot situation? Was the EV stuff taking away from biofuels?
Yes. I mean, it makes it by dramatically overplaying the benefits of EVs, it undercuts the benefits, the actual real world benefits that biofuels bring. Like I said, there's a provision in the statute that talks about doing something similar for alternative fuel vehicles. And for a number of reasons, that's kind of been hard to realize. And so what they did is they just took it and used it for a different purpose, in contravention of what Congress said. In terms of like what it means for the future, it's really about leveling the playing field. And that's probably the biggest benefit here. Is it means that this thumb on the scale is gone. And that's a big deal.
What are those first steps then? What changes with the outcome of this court?
So it's a little bit unclear exactly what the regulatory system is right now because of the way their ruling was written. But basically, it gives the job back to the Department of Energy to come up with a new rule that follows the law. And the Trump administration has already said that they're working on that. So we can expect them to come out with something soon. In the meantime, automakers will know that this isn't going to be the approach that's used in the future. And sometimes this could create a little bit of a pinch while you're trying to figure out what comes up next. But actually, one of the things Congress did in the One Big Beautiful Bill Act is it actually zeroed out the penalties for fuel economy compliance. So even if you don't comply, you don't have to pay a fine, is basically what the One Big Beautiful Bill says. So automakers are not behind the eight ball here. There's a little bit of breathing room to figure this out. But the long-term consequences are clear. It means that this multiplier, multiplying by 666%, the efficiency of an EV is going to go away.
Does this have any impacts then as we move forward on EV in general? Is this going to reduce their capabilities? Is this something that was considered by the judge?
The court was doing legal interpretation. It wasn't trying to make policy itself. And really, that's kind of the main point here, is that Congress gets to make the rules, and it gets to decide who gets incentives. And if it doesn't do that, then, it can't be an agency that comes in and makes it up, and it can't be a court that makes it up either. So that's the kind of the bottom line of this decision. The consequences for electric vehicles are, it's going to be significant in the future. Basically, what the Biden administration did is they made electrification their key climate thing. And this is one of only 15 lawsuits that we've brought, a lot of which we've brought on behalf of folks in the ethanol and corn industry, including a lot of state corn growers, Missouri corn, Illinois corn, national corn, challenging attempts to mandate electrification. And it's all kind of interlocking. And so what this does is it takes one of the tools that they were using to push that without Congress's authorization, and it just says you can't ever use it for that purpose again.
Is there anything additionally around the scope of this question and the scope of this case that will impact biofuel producers, maybe directly, maybe indirectly?
It doesn't directly influence anything because it's really about getting rid of a handout for electric vehicle manufacturers. But what it does is it levels the playing field significantly. And really that was the big distortion here, was using every regulatory tool that the Biden administration had to try to increase EV adoption. And they did it by hurting biofuels, by hurting American consumers, by making ordinary folks pay more for conventional vehicles, and by being dishonest really in the way that they evaluated the costs and benefits of that. And what we're seeing with this administration is a return to following the law and to doing sound policy. And what this does is it provides a rock solid backstop that will prevent a future administration from trying again to use the law in this improper way to force electric vehicles on the rest of us.
During the Biden administration, there was a push for electric vehicles, and some felt it was overly pushed. How does this affect that whole landscape of lawsuits?
Yeah, so there are a whole bunch of lawsuits that we've brought, including a lot with state corn growers like Missouri and Illinois corn. And this is one more victory. Actually, the string of victories we've had has been unbroken, and we've been undefeated in court in challenging this, not just only with this petroleum equivalency factor thing, but also challenging California's regulations that were knocked down by these recent Congressional Review Act resolutions. We had a win in the Supreme Court recently on one of these issues too. So it's taken a long time to get here, but this is just the latest victory in stopping what was a totally illegal campaign to force electrification on the rest of the country at the expense of consumers and farmers and ordinary Americans.
Michael, on that note, are there any other lawsuits on a similar vein that are ongoing at the moment?
Yeah, so the Trump administration has been great on turning the ship around. And so most of the cases that were against the Biden administration rules are paused while they're redoing those regulations. But California has promised to Trump-proof its own electric vehicle mandates, which are extremely aggressive and go to 100% electrification in under a decade from now. And Congress actually repealed those using the Congressional Review Act, and California has sued. A whole bunch of corn folks have moved to intervene, along with AMFRE, the plaintiff in this case on the petroleum equivalency factor. So national corn, Missouri corn, Illinois corn, a whole bunch of other folks. And we've moved to get involved in that lawsuit and to get it dismissed precisely because it's an outrageous argument to say that Congress can't pass a law saying you can't have an electric vehicle mandates, which is what they did. So that's in the hopper, and that's cooking. We're going to get resolution of that in the next several months to a year, we hope, and it's going to be yet another nail in the coffin of electric vehicle mandates.
Michael Buschbacher is a partner with the law firm Boyden Gray, working on this legal case that was a victory for biofuel producers. Thank you so much for joining us on Farm Your Daily.
My pleasure. Thank you.
This is Farm Your Daily, a Field Forward podcast. Thank you again so much for listening. In order to continue to produce this type of local content, we would love to have you join our community. So please follow the podcast as well as our social media channels at Field Forward Pod. You can also find me on social media at Geiger Reports. Again, I am your host, David Geiger, and I'll be back again tomorrow, everybody.